All right, picking back up with chapter 19, let's talk about suretyship and guarantee. All right. Um, the suretyship and guarantee, you may recall from 2080 legal environment, that is one of the statute of fraud exceptions, which means, of course, that it has to be in writing to be enforceable. So when we're talking about sureties or guarantors, if the creditor is not able to produce a written signed document signed by the surety or the guarantor, you don't have an enforceable agreement. I can tell you all day that I will guarantee the debt of another person, but if there's no writing evidencing that agreement, then you can't hold me to it. You can't enforce that agreement. All right. The difference between the two. So, sureties are co-liable, which means the debtor does not have to default to create liability for a surety. All right. If I sign a contract as a surety for, let's say, a relative who's buying a car, right? I'm liable from the day that financing agreement on the vehicle is signed, because as a surety. Whereas a guarantor, liability is triggered by default of another debtor. So if I same transaction, but I sign as a guarantor, I sign as a guarantor of the relative who's buying a car. Well, they have to default before I can be held liable. So that's the difference between the two from a legal standpoint. Okay, so things that the creditor can do to affect or release the surety or guarantor from their obligations. All right, materially modifying the agreement. So if the creditor agrees to accept lesser payments over a longer period of time after the financing agreement has been signed, well, that's a material modification, and that's going to discharge or release the obligation of the surety or guarantor. All right. Surrender of property. This is most relevant when the property is held by the creditor. All right. And so let's say that I have a Rolex watch that, or not even me, the debtor has a Rolex watch that he offered as collateral for a loan. I've co-signed as a guarantor, and the creditor gives the Rolex back to the debtor. Well, they've surrendered the property, the collateral. All right, that would discharge my duty as a guarantor. All right, and obviously payment. So if I pay the obligation in full, I have no more obligations as a surety or guarantor. Defenses to payment. Obviously bankruptcy. We've seen that a few times, and we'll previously in this semester, and we'll see it more as we progress. We actually are going to do a chapter on bankruptcy. But a surety or guarantor files for bankruptcy, that obligation can and most likely will be discharged. All right. Statute of limitations. So for debts, all states have a statute of limitations, which is past a certain point of time, and it's usually from last contact, or if the guarantor had made a payment, it would be from the last payment. but otherwise it's from the date of the financing agreement. All right. Um, Statute of limitations, when it runs, it's no longer a legal claim. All right. Assuming the surety or guarantor does nothing to reaffirm. You can always reaffirm a claim that's ran due to statute of limitations. It's never in your best business interest to do so, but that could happen. Fraud. So fraud in the underlying transaction. Will be a defense as well, right? So you may remember from your intentional torts, the tort of fraud, all right? Anything that falls under that category is going to discharge, assuming you can prove it, would discharge or I should say would be a defense to payment, all right? Rights of the surety or guarantor. Subrogation, which really just means that the guarantor can stand in the shoes, the surety or guarantor can stand in the shoes that the debtor would also stand in. So what I'm saying is if there's a claim against the creditor for some breach or default, then the surety or guarantor can also bring that same claim as a defense to payment. All right, and that's called subrogation. Reimbursement. So while I have assured or I've served as a surety for your loan and I've had to step up and pay, say $10,000, I have a right to reimbursement, which means the debtor now owes me $10,000, and I would be well within my rights to sue the debtor. All right. This doesn't happen so much in family transactions, but it can happen in business transactions because oftentimes one business will surety or guarantor for another business due to prospective business relationship. If we're expanding into a new territory or developing a new product line, there's any number of reasons this may happen. And the debtor, the company that's actually borrowing, defaults, the guarantor has to step in and pay. They're going to be entitled to collect reimbursement from the company that defaulted. All right. Contribution. This also is much more common when in the more complex business transactions where there may be multiple sureties or guarantors. The liability is joint and several. So if guarantor 1 pays the entire amount, and there's a really good example in the book. But so there's $15,000 owed, and there are 2 guarantors. Guarantor 1 pays the entire $15,000 to the creditor. Well, guarantor 2 has to contribute half of that amount, assuming they were equal guarantors, or $7,500 back to guarantor 1. And the net result is they both contributed the same amount. That's why it's called contribution. All right. Debtor protection. All right. So there are protections that are designed to prevent debtors from being destitute. All right, from losing absolutely everything in either an adverse judgment or from creditors suing or compelling into bankruptcy. All right. So the most central homestead exemption is or I should say the most essential protection is the homestead exemption. All right. Um, and in the state of Ohio, well, generally, in most states, it's either the entirety of a home or a certain amount of equity in a home. All right. And certain states, if you have one home and it's worth $8 million, then you could that's just exempt. But Ohio is not one such state. So in Ohio, your exemptions currently, as of the date of this recording, $145,425. Those are indexed, and they change every 3 years. They increase every 3 years, right? And I'll post a link to this so you guys can see it. But that's for your residence. A vehicle for transportation. Again, if you needed to get to work, you can protect that as well. All right. In the state of Ohio, it's not a really nice car. $4,000 is the value of the vehicle exemption. All right. Clothing, subject to certain restrictions and limitations. In most states, it falls under property, but again, you need clothing to keep your livelihood and continue to exist. So obviously, their clothing. Tools of the trade. So if I am an auto mechanic and I have expensive tools that I use for my livelihood, I can protect those up to, in the state of Ohio, $2,550. All right. Pets. Generally, you can keep your pets. Livestock, which really falls under the tools of the trade. I think because if I've got livestock, chances are I am maybe a poultry farmer or a beef farmer or a cattle farmer or what have you. So those generally are exempted up to certain limits as well. All right, so that's how debtor protections work, and those are the most common. It gets a lot more expansive than that, and we'll get a little deeper into that in our bankruptcy chapter. All right.